Well, here's our topic: ethical issues in transactions and disputes in Washington. What we always try to do is make sure that a transaction doesn't turn into a dispute. So if your contracts aren't written very balanced or very clearly, if anything's written over a 10th grade English class level, problems. I'm just saying. You'll see it in contracts and you wonder, why do these attorneys draft these giant paragraphs that look like they're a single sentence? And to read one sentence, you got to keep 3 or 4 balls in the air the whole time. You don't know which clause comes first or second or third. Those are the transactions that lead to disputes. And so what we're going to talk about is how do you ethically act, mostly as an attorney, but you know, ethics aren't limited to attorneys. Surveyors are supposed to exercise ethics, engineers. You don't have to be a pastor to exercise ethics. In fact, everybody should exercise ethics. One key thing about ethics right off the bat that doesn't have anything to do with any state rules or anything is that you'll find through this whole process that ethics are not something you think. They're something that you do. They are things that you say. And furthermore, they are things that you do and say at particular points in your relationship with people, be they clients, be they opposing parties, be they opposing counsel, be they courts. It doesn't matter. It really imposes on attorneys an obligation to be express about what we're talking about. So the Washington rules, and this is probably true for a lot of law, and I think it's maybe a good idea in a free society that it is true about a lot of law, is that it is a minimum standard. It's the minimum. You can't go below it. You got to do at least that. But the aspiring attorney, and I don't mean the new guy, I mean the old guy who's still aspiring, is going to reach ahead and say, well, what can we do that's above and beyond? That's what they call above and beyond. So these are minimum requirements. And the role of the attorney is not only the evaluative function that we talked about before, evaluating the problems. This is kind of a thing you do in your head or maybe with other people, but it's an evaluation function. There's an advisory role. And here is where we come into the what do I do, what do I say, and when do I do it and say it. And then there's this thing called the translation function. Now the translation function is something that I think is a piece of being an attorney that is really minimized. Now, some approaches to being legal counsel is as if I'll tell you what you need to know when I'm done. I'm almost there. We appreciate your patience. But it's all behind a curtain, you see. It's all hidden. And here in the Washington rules, and I'll read right out of the material, each lawyer must find within his or her own conscience the touchstone against which to test the extent to which his or her actions should rise above minimum standards. But in the last analysis, it is the desire for the respect and confidence of the members of the legal profession and the society which the lawyer serves that should provide to a lawyer the incentive for the highest possible degree of ethical conduct. Now this is a little tough because, you know, what if I don't care about what you think about what I do? And I could be a dangerous actor, couldn't I? Anybody, if you don't care what other people think, then, you know, the Washington rules are kind of going to fade away. And so I think we need to look to either your own inner conscience or your own concern for avoiding Dante's 7th or 8th level in the Inferno. If you haven't read Dante's Inferno, you should do it. But maybe if the rules just are minimum standards, then that will be good enough. So according to the state of Washington, it is. But let's go back to this translation function. You know, the U.S. Constitution begins with what 3 words? we the people. So what does this mean to an attorney? To me, this means that here we have a republic that's governed by the citizenry, governed by we the people. What that means in turn is that the lawyer's job has to be to translate the law, which is really overly complex, quite frankly, into something that a non-attorney can understand. Because if the non-attorney cannot understand their legal case, then how are they supposed to say, go ahead? I mean, if I went to the doctor and I said, hey doctor, what do you think? He's like, well, we got to cut your leg off. Whoa, what? Cut my leg off? Why? Now the doctor has to do a translation function. He knows all the chemicals and all the bones and all the blood vessels and everything that goes here and there and the drugs he could give me and everything. I don't know any of that. He has to translate that into something that I can understand so that I will be able to live with the rest of my life that he had to cut my leg off. And this is the same for attorneys. It's the same for surveyors. Why did you put that monument there, Mr. Surveyor? Well, because, you know, the 1/16th quadrant was 57 feet off on the 1957 survey. But, you know, the way the occupation has gone in this neighborhood and talking to the neighbors, I think the guy's like, what? What is this? Some kind of gibberish. And so when the Constitution says we the people, it means people need to understand the law, not just the lawyers. So one of my missions in being a lawyer, and one of your missions I suggest to you should be, is to make the law available to people with a 10th grade education. It's hard to go down to a 6th grade education, but you don't have to go to a college education either. You can just go to a person that just went into their 10th grade English class, and you know how hard those classes were, if you remember. I certainly do. That if you can translate to that level, then you're really speaking to we the people. So here's an interesting thing. In the preamble to the Washington Professional Rules, it says, as advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. Then it says, but as advocate, a lawyer conscientiously and ardently asserts the client's positions under the rules of the adversary system. Then it mentions a third function. As a negotiator, a lawyer seeks a result advantageous but consistent with requirements of honest dealings with others. Now before and later in this class, we'll talk about who is the client. But let's first ask the question, who is the attorney? What's the attorney's role? And is the attorney cognizant enough about their roles to understand that they might be moving from an advisory position to a negotiator's position to an advocate's position? And when do those things happen? And what do you do when they do happen? How do you know? Do you document them? You probably should. So when we look at both land transactions and disputes, which is the focus of this class, we can start at the transactional level. These rules apply immediately in a transaction. And so if we look at a transaction, the lawyer is immediately in an advisory role, an interpretive role, and perhaps in a negotiating role if they're talking to the other side. So if you hand me a contract to purchase a hotel and you say, Art, I got this contract from Wyndham of America. They own the Comfort Inn and they want me to buy this hotel. They're going to be the franchisor. I'm the franchisee. It's 58 pages. Tell me what it says. Okay, so now I have to do an interpretive function and an advisory role all at the same time. It's the same thing that happens with a boundary dispute or a land dispute, is where you look at documents, you interpret them. In transactions, we look for things that might lead to later lawsuits that are avoidable now. In most states, contracts is handled by the law. It's not handled in equity. Remember this morning we talked about equity, what's fair. Now some states we call them equity states because the judges are constantly saying, well, I don't know if this is fair, let's do this, let's do that, and they're just making stuff up. But in a contracts case, there are other jurisdictions that are just law states. And the law is like the guillotine. The law is, this is what the law is, this is what you got, you signed it, you're done. There's no getting out of it. Washington is much more of a, leans towards an equity state than a law state. Idaho leans, Montana leans much more toward a law state. But the contracts always start out with the same legal interpretive function. That is to say, what does it say? Is it ambiguous? If it is, how do we know it is? And then what do we do once we find an ambiguity that needs resolution? Some contracts, we build in ambiguity on purpose because we don't know the price for the installment contract 2 years down the line. We don't know certain things that will happen. We'll say the market price at the time. It's totally ambiguous. Nobody knows what it means. But at the time, we'll be able to find out because it says the market price at the time. So in the earlier class, we talked about finding out what the client knows, looking into the public records. But many times with a contract, all you do is get the contract comes in. The client comes in, he says, here's the contract, what do you think? My first question is, well, have you read it? Because immediately what I need to know, especially about a new client, you know, not all clients are old clients that I've known for years. Some new clients, I don't know what their education level is. I don't know anything about them. And I'll ask them all that. And I'll tell them why I'm asking. Because I need to know how your brain works. Because I need to do a translation of this complex document into your brain. So I need to know about you to learn how to do it. And what parts of the contract made you nervous? What didn't you understand? Let's go through and circle those and figure out what they are. Because in a 58 or a 70 or 100-page contract, it's probably not necessary for me to go over every little jot. However, there might be, and usually are, significant portions of the contract that dovetail with other portions of the contract. And you can't understand paragraph P unless you understand paragraph B, C, and D. They all impinge on P. They all reference each other. And then for this whole transaction, you know, there's a calendar that goes all the way through it. And does the calendar make sense, given the needs of the parties? We have to figure all this out. But, you know, the question here is, what is the difference? Is an attorney allowed to be less than honest when they're ardently asserting? Can an attorney not ardently assert in a negotiating context? I mean, what are the tools that I will use in an advisory function that differ from the tools I use in an advocacy function? We talked about earlier the client walking in and trying to pre-decide your scope of due diligence. You can't obviously let your clients do that. If they bring in a whole pile, just take the whole pile. You know, we're going to just copy it the way you gave it to us and give it right back in the absolutely gargantuanly disorganized way you gave it to us, unless you want us to organize it for you. And if you say it with a smile, you get away with being able to say things like that because people like it when you're forthright. They do. So it's also easier, so you might as well be it. But first of all, now that we've got, you know, who's your boss? Well, the boss is the client, but your boss is also the state bar. And your boss is also, that means, therefore, the state Supreme Court. And sometimes the boss might be wrong for your situation. We can't pretend that the rules cover every situation. In fact, any ethics class I've ever been in, they give you this snarled fact pattern that there's no way that it's got to come out of a law school class, right? The professor just dreamed it up just to give you all these 6 or 7 ethical dilemmas in there. And so sometimes, according to the circumstances, the rules might not quite hit it on the head. And that's where the lawyers get paid to make the judgments, to say, well, it could have fallen here, but I thought it felt there, and here's why. And you have to come up with a way to justify what you're doing. Now, let's talk about who's your client. Prospective clients. You know, Washington law is just like most jurisdictions. I think Idaho's the same way. It's very, very fuzzy on this topic. If you go look at the Washington Rules of Professional Responsibility, there is no definition of a client. You can't, there's no definition section that goes client. A client is someone who signs an advance fee agreement and gives you a retainer of X amount to put into your trust account, whom you have agreed to advise for the following scope of work. That's just, it doesn't exist. And so even before you open your doors as an attorney, and even if you keep them open after 40 or 50 years, you always have to ask yourself this question. Here's what the rules say at 1.18. Quote, a person becomes a prospective client by consulting with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter being a legal matter. And then the courts lovingly say, quote, determining whether an attorney-client relationship exists necessarily involves questions of fact. So again, we're faced with a situation where there are many facts and you have to figure out, is this person being an attorney? Now let's just march through an interesting situation. Here's what the State Supreme Court of Washington said in the case called the Bond case in your notes. It's B-O-H-N. It says, the essence of the attorney-client relationship is whether the attorney's advice or assistance is sought and received on legal matters. So I'm at a Christmas party. Up walks Joe. Hey, Art, you know, I wanted to talk to you about this one thing. It's a little thing. It's no big deal. You know, it's about a fence I have on my property, and I think the neighbor is getting a little weird about it. Is the attorney's advice or assistance sought or received? It sure sounds like it to me. But, you know, it goes on, the relationship need not be formalized in a written contract, but rather may be implied from the party's conduct. Art, you know, come on out on the veranda. Let's talk about this a little more. So we go out on the veranda and we talk. Now we're in private. Whether a fee is paid is not dispositive. In other words, they don't have to give you any money or not. Wait, before we go out on the porch, Art, to talk about this, let me go get you a drink. Is that a fee? You know, I've actually had people come up to me and do this. They go like this. Art, I want to ask you about this thing. Here. And they put $1 on the table. And I'm like, okay, well you got 30 seconds. You know, because I mean, I have to disclaim this, right? Like I could give them a legal opinion based on $1? Seriously? My professional liability insurer would go through the roof, as they should, right? Oh, Art's doing work for $1 at the party, on the veranda.
But you could refuse.
You could refuse, yeah. And sometimes I take the money and I say, well, I'm not giving this back, but I ain't giving you any advice either. And I hold it out there, and some of them snatch it back because they're smart.
Because they need it.
Listen to this one. This is all within one caption in your. Yeah, the existence of the relationship, quote, turns largely on the client's subjective belief that it exists. I felt like I could rely on Art's advice when we talked at the Christmas party. Do you have any idea, says opposing counsel, how much liquor Art had consumed before you requested his advice? His wife had taken his keys publicly 10 minutes earlier. And you're asking him advice? Really? In my defense. You know, you don't drink like that after age 40 unless you really have a problem. If you do, ethical issues will arise and you should seek counsel. But now listen to this. Now we're going to back off a little further. The client's subjective belief, however, does not control the issue unless it is reasonably formed based on the attending circumstances, including the attorney's words or actions. This is actually helpful because it gets back to what we started with, which is it's either what you say or what you do. So if the attorney outright refuses to give legal advice or gives a disclaimer that says, I really haven't done any due diligence on this matter, so I can't give you any legal advice whatsoever. However, I can give you a broad view of the law in this area. And then I can give them a whiteboard discussion about 1100 AD and the king and the courts and equity and all that kind of stuff. And I will never give them a conclusion about their case because I have done nothing. I've done absolutely nothing. So you just can't do it. If someone believes they're seeking legal advice from you and you give it to them, then they are a client. Even if there's no contract, whether or not money is paid to you, or whatever the attorney thinks. So as an attorney, this is why when you go to a party, if you're an attorney, and somebody asks you a question, you notice this about attorneys, they always wait. You say, hey, Art, what time is it? And I'm like, time, let's see, we're in the Pacific time zone, but we just had cake, so is it time for a drink? Time to go home? Time to sing happy birthday? It's 4:15. And you give them the answer, but there's always that lag because every time you ask an attorney a question, every single word in your question is going through the thesaurus in their brain. And every single possible iteration of every single word goes through the thesaurus, and then they reconstruct it into the several questions that you could possibly be asking. And if they're really smart, they say, well, what do you mean? Just to kind of get you to tighten it up a little bit, clarify it a little bit for me. So this is the line between a prospective client and a client is determined by the circumstances of the meeting, the subjective beliefs of the person who is talking to the lawyer, coupled with the conduct of the people involved, whether at a party or poolside, at a structured consultation, or across the back fence with a neighbor. Now, I've literally had this happen to me. I'm walking the fence line with a neighbor, with my client. We're walking the fence line, looking at the fence. Look at these cedar fence posts. They are wired to a metal post, which is holding the cedar fence post above the ground, and there's actually room. You could run your foot under the bottom of the cedar post. It's obviously the metal post that's holding it together, but because of the presence of the cedar post, doesn't it look like an old fence? Yeah, that fence has been there for years. No, they just drove those metal stakes in last week. And this client gets a phone call, so he steps away over there. And I'm sitting there looking at this and that, and up comes the neighbor. What are you guys talking about? What are you doing? Well, we're looking at the fence. Do I get to talk to this person? Are they represented by counsel? Do I get to even talk to them at all? I mean, I don't know. So I always dodge. I just take the dodge. I say, let's wait till Bill gets off the phone and we'll see what he has to say. No, I don't want to talk to him. Oh, okay, well, if you don't want to talk to him, odds are that I shouldn't be talking to you either. But it's nice to meet you. And then I walk away. And you want to be that clean cut about it. You want to be that, just sever it. You don't leave room. Don't be squishy, because in their mind, they're going to go back and they're going to talk to their attorney and they go, oh yeah, Art talked to me about that fence. Oh yeah, he said this, that, and the other. It's just going to happen. So you need to be careful about who you consult with. Conversely, if someone comes up to me at the party, say now we're back at the party, and they come up to me and they say, Art, I got to tell you about this fence situation. It's unbelievable. My neighbor did this. My neighbor did that. I can't believe what's going on, and I might have to call your office, but I'm not sure. And do you have a business card? Well, what am I to do? Give me a call. That's all I can do, really. That's if a client unilaterally comes out and starts telling you stuff. Like some people will just, we have a tri-state practice. So we have about probably 40% of our clients we've never met. They live in Arizona, they live in Illinois, they live in New York, Florida. We don't know where they, well, we know where they live, but they don't live in Idaho. They've never been there. They don't live in Washington. They don't live in Montana. And so we tell them, they'll send us stuff, even before they're clients. I need somebody to help me out with this contract. Bam. Well, we don't even look at the contract until we go through all the motions of setting up the attorney-client relationship so that it is functional and it works and everybody knows their position in it, including us and the client, before we even read page 1. And if they don't want to get involved in the representation qualifications and the agreement, then we're not going to talk to them about anything really at all. We're going to say, thanks for calling the office, but it looks like we won't be able to help you. So the difficulty of identifying the client in the mind of the person the lawyer is speaking with requires the lawyer to either provide no information or accept the liability for advice given, or to expressly state when they are communicating on behalf of a client. So just like in boundaries, good fences make good neighbors. So let people know your boundaries. When an attorney writes a letter to an opposing party, to really anybody in an official capacity, they should always say right up front, I'm writing on behalf of Mrs. Jenkins, your neighbor next door. She's been concerned about the fence dispute for some time. She doesn't really want to have a big, brouhaha over it. Now, I don't write brouhaha in a letter, but she doesn't want a big battle over it, but would like to resolve it. Here's what we found out. And then I give them my evaluation. I just give it to them. I don't give them the legal advice and things I gave to the client before, but I will give them the law and the facts. And I'll say, here's what I think we should do. So we always identify ourselves and we tell them what we're about when we write to them. But the dangerous thing is when you're not on guard. When I'm not wearing my coat and tie, when I'm wearing my sweatshirt, when I'm just walking down the street and somebody goes, you're Art Macomber, that real estate guy. Can I ask you a question about this? I'm like, well, I don't know. Maybe you shouldn't. People are people, right? So if they don't know any of the strictures that govern me, the attorney, under the Washington professional rules, I'm obligated to give it to them. And sometimes the best way to give it to them is to throw them off guard a little bit, because I can tell you right now, the person that approaches you on the street or at a party or anything else is just going to barrel ahead with this great story. And I guarantee you're going to want to hear it, especially if you've had a couple of glasses of wine. You're going to be like, sure, tell me all about it, right? But that's not a good idea. So you can get their attention and do it. So here's a couple of examples. Someone calls your office and asks about Washington real estate disclosure laws. Well, there's no client. Do we even want to talk to them? This is why when you call most attorneys' offices, the attorney does not pick up the phone. Right. There's a screen. Why? Because if you get the attorney on the phone, now the attorney has to give all these disclaimers and who are you, and maybe I have a conflict with you, I have no idea, right? And so it's kind of dangerous to pick up the phone. Now, I picked up the phone in my law office for the first, 8 years? And even if everybody's out of the office, I still pick up the phone. But I do say to people right out of the chute, I'll say, look, you're not a client, I can't give you legal advice. If you'd like to make an appointment to come in, we have a 45-minute consultation, but you're going to have to talk to the receptionist first so they can get all your personal information. We'll find out who the other parties may be to make sure we don't have a conflict of interest before we even talk. Doesn't that make more sense? And they always think it makes more sense. Or sometimes they don't, and they say, well, I just wanted to ask you this one thing. And it's like, well, I can't answer you this one thing. So you have to be a little strict. Now, here's another one. Someone calls and asks whether you handle real estate closings. Well, this is kind of a question about your function, your area of practice. So you might say, well, yes, we do. But I still want you to make an appointment to come in to make sure we don't have any conflicts in the situation. Because you can still have a conflict when you're working on behalf of both parties doing a closing. Here's one. This is one of my favorites. At an annual members meeting with your client's homeowners association, so your client is the homeowners association, a homeowner approaches you and asks whether his children have to store their bicycles behind the fencing overnight. Well, you're the attorney for the HOA. You should know this, right? Can I read to them what the CC&Rs say? Sure. Can I tell them what that means for them? Probably not. Do I need to tell them right away that I'm the attorney for the HOA? And so you need to understand that I'm working for somebody who might be not enjoying the fact that your kids leave their bikes out, that has to enforce that rule. So I can show you what the document says. Here, I have a copy of it right here, but I can't tell you what it means for you. Well, it means I have to go get an attorney to tell me that. I said, well, you're free to do whatever you want. I'm just telling you that I'm working for the other guy. Oh. It's frequently not fair, but it is proper too. So you draft, here's number 4, you draft a purchase and sale agreement for a land conveyance on behalf of the seller, and the buyer calls you to request information regarding the meaning of your indemnification clause. These clauses are notorious for being giant paragraphs of 3 sentences max and 200 words. It's unbelievable. I mean, it's hard actually to construct a sentence like that. But in the legal community, sometimes the writers think, well, if we don't include everything in the sentence, then everything won't be accounted for. Because if you put a period, then maybe that means we're done with that and we'll go on to the next one, as if paragraphs aren't in context on the same topic. Like you were taught in 10th grade, right? You have a topic sentence, and then you discuss the topic, and then you conclude. What? That shouldn't be so hard. But the answer is you really can't talk to them about the indemnification clause. You represent a buyer in a real estate transaction and you call the seller unrepresented by an attorney to clarify whether the contract is in US dollars or Canadian dollars, and the seller asks you, does it matter? Well, maybe it does. You know, up here in the Pacific Northwest, we get people doing business in Canadian dollars. And a lot of the contracts you read, they don't say 250,000 US dollars. They just say $250,000. And so a good attorney's going to go, oh, wait a second, is that US or Canadian? Because it's reasonable that it might be either. So now you got an ambiguity. You represent a seller in a real estate transaction, and during a site inspection, the buyer's appraiser walks up to you and asks you about those 55-gallon drums over there. Really?
You didn't have your client to get them out of there first?
You know, we'll have to talk to the seller about that. Honestly, I'm just standing around here looking pretty. I mean, I can't help you with it. And then we have number 7 that I mentioned before, that you're walking a fence line and neighbor steps out and says, what are you doing? Here's the problem. Under the circumstances, the person you're speaking to, the non-attorney, whether they're, you know, a surveyor or a state senator, or it doesn't really matter. If they're not an attorney, they may believe that the attorney's in a position to give legal advice. And it's up to the attorney. The onus is on us to make the required disclaimers and to separate the boundaries. My client's on this side of the fence, you're on that side of the fence. I'm not going to get into a boundary dispute about client matters, much less the one about the fence. Okay. So clients sometimes morph. We talked about this a little earlier. You know, let's just briefly cover the bullet 3. What to disclose. You need to disclose as an attorney who your client is and what you're doing. Now, I'm not saying you give the aims of your client's representation, but you should say, I'm working on behalf of Mr. Jones, and we're working on this fence issue that has apparently cropped up. I mean, that's totally fair. Well, what can you tell me about this situation? Well, I can't, because you might take it as legal advice from me. And I can't give you legal advice because I'm already advising someone who you might be in opposition to, Mr. Jones. So unfortunately, I'm going to have to tell you that you need to get your own lawyer, or you can always talk to Mr. Jones. That's not barred by the rules. But I can't really talk to you. I'm not allowed. So that's really the rule, is the attorneys cannot talk to opposing parties. They say if they're represented, but there's a danger even if they're unrepresented. If they're unrepresented, can an attorney talk to an opposing party? Sure they can. But do you have any idea what kind of disclaimers you have to make in that situation? It's very tough. But the rule is that just a second, the legal system encourages settling of disputes. So the parties can always talk. There is no rule that the opposing parties can't talk to each other. And that would be kind of silly. Some attorneys don't want to do that because they want to just control the situation. Don't talk to him. Go through me. I'll go through the opposing counsel. It's safer for you. The only thing I tell my clients is, look, if you want to talk to your neighbor, you should. But just don't agree to anything. And whatever they propose, if they propose something to be done, say, you know what? Let me go think about it. Let me talk to my attorney about it. For those of you that are married, the best one, I need to talk to my wife. I need to talk to my husband first. It's very simple. Yes?
It just seems a little confusing with what you said earlier about going and talking to everyone, everyone around the area. How do those things go together?
If I'm working for a client and I want to go talk to the neighbors, I want to identify myself to the neighbors. I want to say I'm working for a party down the road. And, best practice is to talk to your client first and say, look, can I use your name? Now, some clients are going to say no. They're going to say, no, I'd rather not. Say, well, I'm going to go ask some questions anyway. And just say, I'm working for this party down the road, and we've been concerned about, kind of the lay of the land here and how it works, and some of the fences were put up, and we don't know when they were put up or whatever. And so, I want to ask your opinion on this situation, on these fences. Now, if it's the neighbor next door, odds are I'm not going to do it. I wouldn't talk to somebody who would definitely be an opposing party. What I've found, though, is that human nature makes the social glue that holds communities together much more intertwined than you might imagine at first glance. You'll be surprised at what somebody 5 houses down the street knows about you, or knows about their neighbor, or knows about where they went to church, or knows about where they shopped, or saw them at Costco and heard that this other thing was true. And those things bind all our communities. Now, as an attorney, I think it's too high risk to be working for the person on parcel A and then go across the fence and talk to parcel B. I think that's really dicey. Because I can say all day to somebody, look, I'm representing your neighbor, I can't represent you. Is that going to stop them from peppering me with questions and believing that because they talk? See, because here's what happens. Next week, they go talk to somebody and they say, I talked to Bill's attorney next door to me, and you know what they told me? And it doesn't matter what comes out of their mouth next. The person hearing it is going to go, that attorney gave them legal advice. Even if I said the best price on macadamias is at Trader Joe's on South Hill, it's not going to go. They're going to say, they talked about that fence sometime or another. I'm pretty sure of it. So just, not a good idea. Okay, let's talk about, let me see, parties in opposition, we got that. Opposing parties, morphing clients. Corporations can change, they can dissolve. You can have a full-blown homeowners association for years with 5 of the most stable, competent, easy, amiable people, and they get replaced at the next election by people completely different. I worked with the homeowners association for 6 years straight. We got a lot done. We got it out from under declarant control. We did everything that you might imagine. We expanded it from a 3-member to a 7-member board. Everybody was happy. 4 of the new members decided they wanted to fire everybody who was pre them. So the snowplow guy got fired, the landscaping guy got fired, the homeowners association management company got fired, the attorney, yours truly, got fired. Now it wasn't like, you're fired. It wasn't negative or anything. It was just like, I got this nice letter. We've decided we no longer need your legal services, and please forward our records to this other party. And I wrote back, well, I'd be glad to do so, and I think it's a good idea for people to change attorneys now and again, because I do. And I will be glad to send your file on after the bill is paid, the invoice is enclosed. Because that's really the only power we have. We don't have the power to lien real property. Although from a real property attorney standpoint, I think I should. Because I do the same thing as surveyors and architects and everything. I'm just doing it from a legal standpoint. There's really no difference, but I still don't get the lien. So we get to hold their stuff. We're just going to hold your stuff. Unless they're in jeopardy, then we can't hold it. We have to give it up. So people die. Suddenly you got a client, you're going along, and suddenly the daughter comes in from California and says, Papa died, and I'm the executrix for the estate. We have an ongoing lawsuit. Client just changed on me. I don't know this woman. She doesn't know anything about the case. We're 8 weeks before trial. And I have to not only explain the whole thing, but figure out from her perspective whether it can even go on, because some causes of action terminate when you die. Or if it does go on, how should it go on? So now I have a whole new client. All right. So here's some duties. And I want to talk a little bit about these duties. The one duty is loyalty. How can you exercise a duty of loyalty if you don't know who your client is? And adverse conflicts pop up all the time. If I'm representing a seller in a real estate transaction, I'm not representing the buyer. Now look, if all three of them want to come to my office and talk together, and they're sitting there and I tell them, you're all attorney, you're waiving your attorney-client privilege. All that stuff is gone. But you want this contract language to be different? We can hammer it out now. But if you, the buyer, want to bring your attorney to that discussion, do it. Because now I have to get another person, like my legal administrator or a paralegal or a fellow counsel, to come in and sit with us, so that the parties don't both turn on me and say, well, no, that's not what you said. So I have to have somebody taking notes. I mean, it gets really complicated. So, the better thing is when your alarm bells go off, when you start seeing the red flags, just run away. Just run away. Don't have anything to do with it. And tell people why you're leaving. I can't do this because the risk is this, and I'm not willing to take on that risk. So loyalty, though, quote, prohibits lawyers from switching sides and representing a party adverse to a former client in the same or a substantially related matter. Now, here's an interesting situation. The plat identifies a parcel that goes like this. And here's parcel A, and here's parcel B, and this parcel here is a road parcel. And this was on the original plat when they split it up. Here's a road parcel. It's got a discernible AIN number in Idaho or an APN number if you're in Washington. It's got a discernible property. And you go to the recorder's office and you look it up and they say, well, that's a road parcel. And they give a nominal value to it. There's somebody that has to pay taxes. And what happens is, gosh darn it, they built the road like this. Well, that didn't match up at all. But the surveyor found it out. So now, in order to make this right, By the way, did I tell you there's all these landowners down here that depend on the road to get there? Yeah. Did I tell you that there's express easements here, but there's no express easement for this, for any of them, even though it's on the plat? So, I mean, this is just a gargantuan mess. The surveyor comes and says, well, look, let's make the easement follow the red lines. We'll make it be here. And we'll take all this property and give it back to A. And we'll take all this property and we'll give it to B. And we'll do all these fish cuts through here, these fish, what do they call them? Fish tailings or fish, something like that. Fillets, that's what they're called, fillets. Like when you go and you have a nice salmon dinner and there's fillets all the way through here. We make the appropriate conveyances and suddenly what's in the red line turns out to be the road. And all these people are going, who are you working for? I'm like, I'm going for the guy that owns A and B and serves you guys. Okay, well, what do we want to do? Well, we want to have a road agreement. Okay, well, since I'm the attorney working for A and B, I can help you with a road agreement, but I strongly suggest you have your own attorney look at what we craft to make sure that it meets your needs over time, because in 100 years we'll all be dead, and they'll still have to follow that agreement unless it's changed. So end result was I had my client and all these people over to the IHOP restaurant one morning for breakfast, and I whiteboarded this whole thing, and I passed out the sheets, and I detailed all of it, and we had a prospective road agreement, and we got them all to look at it. They decided to have an association. So we had an association which was basically not a big CC&R gargantuan thing. It was just a road association agreement. So they could plow it, so they could keep it clean, so they could clear the gutters and the culverts and the ditches. And that was perfectly fine because it was all fully disclosed. And by the way, in writing, because I want each of them to understand in writing who I represent. Now, one of them had their attorney come back, and you know what he said to me? He goes, Art, that's an awesome road agreement. My client has no trouble with it. I'm like, yes. You know, it makes you feel great because, you know, a lot of times being an attorney, you run into these things where there always seems to be a dispute. And you always wonder, why does there always have to be a dispute? What is wrong with people? They have to fight all the time. But when they come back and they say, no, you did a great job and we have no dispute, then you just sleep like a baby, I can tell you that. It's awesome. So, but my duty to loyalty was to my client, and then I had to tell everybody what that involved. But I still have to disclose the material facts. Now, in Washington, we have disclosure laws for sellers. They're discussed in the materials, and we'll talk to them a little bit more. But basically, you've got to be loyal to your client, but somehow tell the opposing parties what the material facts are. You can't really hide anything. Frankly, you shouldn't. You know, because here's the thing. There's good facts and there's bad facts. If there's really bad facts, like they caught you with a bloody knife, right? That's a bad fact. The criminal attorney still has to defend against that. It's a bad fact. You know, the survey shows, the plat says, those might be bad facts. But they're usually offsetting facts to mitigate them. And a court is going to weigh the facts. And the court's going to say, well, I don't believe that guy on the witness stand, but I kind of believe her. And they're just kind of going to go like this all the time. So it's not really in the attorney's interest, in my experience, to hide bad facts. In fact, better to get them out there and say, you know, this fact looks really bad, but look, here's the circumstances surrounding it. Here's the context. And it helps people kind of go, well, yeah, that was a pretty bad fact, but, you know, he was holding the bloody knife because the guy just stole his child and was standing next to the window. Oh, now I understand. And suddenly it's justified. So in land transactions, Washington Professional Rule 4.3 is triggered. In dealing on behalf of a client with a person not represented by a lawyer, the lawyer should not state or imply that the lawyer is disinterested. The lawyer shall make reasonable efforts to correct the misunderstanding about the lawyer's role. Now here's the thing, you can't correct a misunderstanding unless you know it exists. And so what the lawyer needs to do is step out and go forward and be aggressive, be assertive about what the role is, about what's going on here. If you have a legal license in Washington, you can't just sit back and watch circumstances develop. You have to step out there and go, well, I'm here on behalf of this person, and this is what I'm doing, and this is what's going on. And make your disclaimers. Okay, the Washington disclosure laws. This is confidentiality. So my seller tells me, oh my gosh, the roof leaks like a sieve. They never say that. They always say, the roof doesn't leak at all. I had a hotel transaction where the seller calls me and he says, the buyer of my hotel wants to sue me. Really? Why? Well, because he says the roof leaks, but that roof never leaked. In fact, we just had a new roof put on like 4 years ago. Okay. And then I go to the other opposing counsel with a letter, and I say, well, the roof, my client says the roof doesn't leak, the roof got replaced 5 years ago, blah, blah. And you know what I get back? I get back an affidavit from a maid in the hotel that says, when I was cleaning the rooms in that hotel, the water was dripping from the ceiling. It was leaking like a sieve. So my client had outright lied to me. And there was no way for me to verify this independently. I couldn't go over there during a rainy day and take my umbrella and go inside. I mean, it wasn't that time of year at all. It was the summertime. So my client said, what am I supposed to do? I said, they want a check for 20 grand to fix the roof. Cut them a check. Oh, really? I said, well, you can spend 60 grand with me and go to court for 3 days in a year and a half, and then you can cut a check. Although when you cut that check, they might have you pay for the attorney's fees of the buyer that you have to pay because you knew the roof leaked. He cut the check for 20 grand. And it was resolved. But you know what? He had to, because he tried to conceal something. And as an attorney, I can't help him conceal it. I can't go over to my Art, we're selling the house. Come on over this weekend. We got some painting to do. We're going to paint over the leaks, the drywall, the wallboard. No. In Washington, you've got, disclosure forms for vacant land, for residential land, 1 to 4 units, for residential land above 1 to 4 units, in other words, all of it, and also for commercial property, all of it. This is as opposed to Idaho, where there is no commercial disclosure laws. There's good faith and fair dealing and all that, and we all get along, but I don't have to tell you anything about the building I'm selling you. In Washington, you do. And all the forms in Washington, if you look on the RCWs are quoted at 64.06, 10, 13, 15, and 20. They all ask about encroachments, boundary agreements, boundary disputes, legal action pending or threatened. Here's my favorite. Any other existing material defects. Now, I can't put myself in a position to hide any of that. And so my personal rule, and not only because I was a realtor in a former lifetime, but I think the better rule is, if you know about it, just disclose it. Just be honest up front. I mean, your property is what it is. If you try to hide what it is and make it something that it's not, I almost guarantee you 95+% of the time, in 6 months, change of season, the buyer's going to know everything. And that's usually what happens. If you sell in the winter, they find out in the summer. If you sell in the summer, the basement floods in the winter. Well, there was no water in the summer, and the seller moved to Florida. But are they out of reach? No, not really, unless they move to Switzerland or something. I mean, if they're in a foreign jurisdiction, they might be out of reach. But you really shouldn't not disclose those things. In fact, there's a statute in Washington about psychologically affected property. So if there's a heinous murder in the bedroom of the house you're selling, blood everywhere, body, oh, geez, it's disgusting, and it's all cleaned up, you still have to disclose it. Because some people feel like the spirit of that person or the energy that was expended during the murder or some other thing is going to haunt them forever. And enough people believe that they actually put it into the statutes. So look, it's just fair to disclose, because if you disclose and you take a lower price, unless the property is worth millions and millions of dollars, the odds are that the lawsuit you have to undergo later when they find out is going to cost more than the amount you drop the price when you're honest. So just be honest up front, and you'll find a buyer. I mean, there's all kinds of people that will buy all kinds of properties regardless of the condition, but you will take a price hit. So the duty to disclose material facts is in real estate transactions, but it's not in real estate disputes. So in a boundary line dispute, I don't have to disclose everything, but what if I'm directly asked? Can I dodge it? Maybe, but would it be proper to dodge it? If I don't know for certain that it's true, then I can't say that something is for certain true. But if somebody asks you a direct question, like if somebody comes up to me and goes, Art, how long has this fence been here? I'm going to have to say I don't know, because what am I relying on? I didn't put the fence up, unless I did, which I didn't. I haven't built any fences in the state. Then I'm taking the word of somebody else. It's either my client, or it's my client said the neighbor said, or something. So I don't really know. But we're here to work out the boundary, and I don't know about the fence. What's a material fact? We won't really talk about the Washington Consumer Protection Act. But in a case called McRae, the purchasers of a home successfully prosecuted an action, which means in normal speak they won, under the Consumer Protection Act when the sellers failed to disclose sewer and drainage problems. The Consumer Protection Act has a public interest element. So the seller's failure to disclose material facts was an unfair or deceptive act or practice under the Consumer Protection Act. And so there's a question about, if there's no public interest element involved, if it's just private parties, would that same case have come out the way that it did? But an attorney making any representations on behalf of a seller, or when making representations about the fence line, or the boundary issue, or what you read on the plat, or anything like that, could trigger a duty of disclosure. Now, in a transaction, you have the disclosure rule, but in a dispute, you don't. So in a dispute, you don't have to go out of your way to tell people that might be material, especially if they're represented by opposing counsel. That's their job. They have to do the due diligence. They have to read the public record. They have to gather the facts. That's their job. And so I really don't have to get involved. On the other hand, I have to act fairly, and I can't, hide stuff. So it's a little bit of a tightrope. You have to make a lot of judgments. Now, a material fact is something that would cause somebody to walk away. That's the basic rule. And I think it's better elucidated in the materials. But it basically is, if a buyer and a seller enter into a transaction and the seller knows something and it would be material to the buyer's decision to close, then if the buyer finds out about it later, they can have the contract undone. I mean, it's a material thing. Is there a 55-gallon oil drum buried in the basement? That would be a material fact, because it might trigger a whole environmental remediation effort on behalf of the buyer that the seller coulda, shoulda, woulda undertaken and didn't. So yeah, you should be disclosing that. You need to be careful because you don't know what's material in the mind of the buyer. And buyers will bring the contract into my office and they'll go to the littlest jot in paragraph 18B and say, well, this is why I should be able to get out. Because they want to get out. And so they want me to take the smallest thing and make a mountain out of a molehill so they can get out of the contract. Now, if they really want to get out, there are usually other ways to do it. But from a layperson's point of view, when they read that document and they want to get out, they're looking for ways to get out. Here's an interesting one. The attorney has a duty to disclose that which the client tells him that is at variance with apparent facts. In a land boundary dispute, an owner may tell their legal counsel that the fence is in the wrong spot and, quote, everybody has known it for years, unquote. An attorney representing this client would want that owner to note on the disclosure form that the fences may not be the boundaries, and that the buyer may want to procure a survey to ascertain the actual boundary locations. So that's for transactions. That's a disclosure issue by a seller. Now, is the buyer on inquiry notice? If there's actual notice, inquiry notice, and constructive notice, and it's not in the public record, and the buyer's never been to the site because they live in Alabama and they're an investor, but they visit the property once before close, and they see the fence, and there's a little bit of variance between where the fence is and the barn is and some of the roads. I mean, things are just a little bit squishy on the ground. Are they on inquiry notice? Probably. Does that mean that the attorney can just say, go ahead, do your due diligence yourself? In most circumstances, yes. In Idaho, definitely yes. In Washington, probably not. The disclosure rules require the disclosure from the seller to actually say things about what they know. They can't just hide it. They can't just say, well, it's not on the form. So I didn't mention the 55-gallon oil tank in the basement because it wasn't on the form. Okay? They're going to find out about the tank, so you might as well tell them. So confidentiality is interesting. When we talk about this versus the disclosure laws, confidentiality extends to secrets, but many attorneys will not even disclose the names of their clients to third parties. I'm one of those people. We represent landowners in one county in Idaho. One of my clients owns over 12,000 acres. It's all over the place. They own a lot of land everywhere. Here in Spokane County, there's hundreds of acres owned by a client. And so, when I see these clients in a public venue, I don't acknowledge them unless they come up to me first. Why? Because I consider it to be confidential who their attorney is. It's nobody's business. I'm not going to walk up to, everybody knows I'm an attorney. I'm one of those people that I might as well not wear the name tag because everybody knows me. Most places that I go, they say, well, oh, hi Art, how you doing? And they all know, and I'm an attorney. So if I walk up to somebody at Costco and go, hey Bill, how you doing, blah, blah, they are thinking, onlookers are thinking, well, that must be a client. And frequently they're right, because I'm too busy to have relationships with anybody who's not a client. It's pretty bad, but that's what happens when you're busy. The clients, though, might acknowledge you first. But from my perspective, the confidentiality is very important. It's nobody's business. That's what we used to say in North Jersey. Look, it's just business, okay? No offense, it's just business. But Washington's state oath that every attorney takes, it says, I will maintain the confidence and preserve inviolate the secrets of my client and will accept no compensation in connection with the business of my client unless this compensation is from or with the knowledge and approval of the client or with approval of the court. So if I'm working for a client on a boundary dispute and I go to the recorder's office to dig up documents, do I have to tell them who my client is? No. But some title companies in some counties will not provide us with a title report on what's in the public record at the auditor's office unless it is for our client. So if my client is Mr. Jones and I want the property records for Mr. Jones, it's okay. But if I want the neighbor's property records, some of those title companies get sketchy. They're like, well, I don't know why you're looking into this. I'm like, yeah, I know you don't know why, but it's okay. I'm working with the neighbor, and we're looking for things that might help us resolve things that are going on with their property, so we need to look at both. Usually that does it. I've never had a title company balk when you give them some sort of information. But sometimes if you're representing a seller as an attorney, the buyer might say, well, what do you know about the local schools? How about, are there any sex offenders living in the neighborhood? Do you have any information about that? Well, I don't know, but you can go check over there. And you can check there, and there on all your other concerns. I'll point people to where they should be doing their due diligence. I think that's just fair. There's no harm to be a little cagey, too. If the neighbor says, gee, where's Bill moving? You can be somewhat vague. He's moving to a home that better suits his needs. Really? He's moving out of state to be with closer relatives. Really? What state is that? Well, you probably want to talk to Bill about that. He hasn't authorized me to talk with you about where he's moving. And the person hearing that immediately says, didn't authorize you to talk to me about where he's moving? Really? Is that even oh, I never thought of that. Of course they didn't. They're not an attorney. They're not trained like we are trained, supposed to be, to tell people what your position is and draw the line when you're not allowed to say anymore. If you can't say anymore, just tell them, look, I can't say anymore. I'm not free to say anything. The client's in charge, ultimately. It's really the client's legal business. It's not mine. So I can't make those decisions. Frankly, I don't want to. There's too much on the line for the client. I want them to make the decision, yeah.
So like sometimes when I'm doing a survey, people next door will want to know why I'm doing a survey for so-and-so. So I just say they want a survey. I don't really need to tell them anything else, do I?
Well, now you're asking a question about the professional rules of surveyors.
Because sometimes they're just kind of almost rude. Sometimes.
Yeah.
I
If I was a surveyor, here's what I would say. And if I was not an attorney, I would say something like, many property owners feel like it's proper to know where their boundaries are. And especially, if they can't find their monuments or something, they like us to do a survey and tell them where we think their property boundaries are. And so, your neighbor, the guy I'm working for, is looking long term. They would like to secure their property values, and having good knowledge on the ground of where their boundaries are helps them maintain their values, helps them monitor the property for encroachments and things. It's just good practice. It's just best practice as a landowner to get a survey now and again. It's completely fair. You don't have to tell them, your neighbor hates you and he's going to come after you over that stupid fence. Even if it's true.
That's it. Even though when I'm looking down, I can probably see why.
Yeah, no, the fence goes like this, right? Yeah, what are we doing? Building pianos? No, we're building fences. No, you really, I don't think you have an obligation. I don't know if you do as a surveyor or not. But I would bet that you did not. But as a surveyor, would you talk to your client about that? Absolutely.
Worried about lying there.
Well, even beforehand, when you first get hired, do you say to your client, when I'm out there doing my field notes and I'm taking notes and all my surveying guys are out there doing all the theodolite or whatever they're using, the GPS or whatever, if the neighbor comes up, what should I tell him? Here's the boilerplate of what I tell people. But, how much do you want them to know about why I'm doing this? But, let them make the decision. Yes, there was a question?
I was just going to comment on, I do a lot of those types of difficult boundaries, and my instruction and when I'm there is to be courteous, be kind, be friendly, but don't talk. We're doing a survey for your neighbor, that's it. And they know there's a survey going on because they already know someone's caused the problem already. There's already an issue usually when I get to that position. And so just be courteous, be kind, tell them you're trying to find the truth of where the boundaries are, and that's it.
Well, for the surveyors in the room, let me posit this difficult one to you. Maybe it's not so difficult. You're doing a survey on parcel A. And along comes the neighbor on parcel B while you're surveying the line. And they say, hey, what are you doing? You say, well, we're just doing the survey. A lot of property owners do it now and again, especially in a rural area like this. We like to keep track. And so I'm just checking the monuments and all that kind of stuff. Oh, really? Well, I have an issue with my neighbor over here. They built a fence over here. And I'm wondering if you could come by and do some work for me. When you're done over here on A, can you come help me on B? Now, what do you do about that?
Conflict of interest, and they have to call.
Is it a conflict?
I think it is.
Okay, just because you did A, you can't do B.
I'm assigned to do A, and that's my mission for today is for A.
So if A hires you and you do the survey and B looks out his window and goes, man, that surveyor looks sharp in that orange vest, I'm going to hire him. And next week he calls your office because he read the sign of your truck and he hires you, and then he goes to work for you and he does the survey, and then parcel A starts a lawsuit against B, and B hires that same surveyor to be the expert witness against A. Is that a problem? Is it?
Yes.
It's a problem. Why is it a problem?
I think it's an ethical violation.
An ethical violation, a conflict of interest, right? That's a real case. That actually happened to me. And boy, was my client A livid. How can he work for me and then work for them? I'm like, well, I don't think he can. Well, so she ends up turning it into the surveyors, organization that go,
What if you were to approach A to request that she acknowledge that you're going to go work for me?
Now let's switch back, because this is supposed to be for attorneys, but maybe it's the same for surveyors. Here's the way it works for attorneys. If I represent A, and then B comes by, maybe 3, 4, 5 years later, this is a former client, they're long gone, theoretically, but not really, they're a former client. And here comes B and wants me to do some legal work that may drag A into it. I am required to get a conflict of interest waiver from A in writing, if I have a half a brain, in writing, not record. We do the writing, but not the recording here, right? In writing. But first, in order for this client to understand, remember, it's like the doctor where they want to cut your leg off. They better disclose to you what the situation is. So I go back to A and I say, well, I've been approached by B to do this work. And my concern is that, I worked for you 5 years ago on this thing that may bring this matter into a problem. Now, from my perspective, if that happened to me, I would say, well, I can't help you because A is my former client. I mean, I'm just not even going to go there. It's not worth it. There are like 33,000 parcels in Kootenai County. There's over 50,000, I think, in Spokane County. I mean, it's crazy. There's no dearth of clients. It's not like you have to take B's business. Yes?
So does that mean you never survey for two neighbors, or only if there's a potential conflict that you can identify? I mean, you never survey for...
I think a surveyor has to make up their own mind about who they're going to do business with. And if they genuinely feel like, by their knowledge of one neighbor and then now their knowledge of the second neighbor, that there might be a conflict that arises, it might be better for them to step away and just don't do the work. Could they sign off a conflict? Yeah.
I can just answer what I do, of course, but if that's the situation, before I ever do any survey, I want to know what the purpose is for, before I even say, yes, we'll do that. Because if there's a situation going on between a client of mine and the next neighbor, and they say, we're fighting about that, I'm going to say, well, you need to find someone else. If they're just trying to be neighborly and come up with a common boundary because it's lost again, I have no issues. But I think it's a question right up front. What's the purpose of the survey? If you think there's boundary dispute going on between a former client and you that you did, then no, that's not going to happen. You find someone else to make sure you have an independent decision. But if it was client C on the other side for B and they're having an issue, I don't have a problem with that at all.
So that is a really good contribution, because the watchword then is, who's my client and how am I going to react to this new request for business? And if you think there's going to be a conflict, I encourage you to ask yourself this question. Would you rather be out on the hustings doing meaningful work, sending out invoices and getting paid, or would you rather be embroiled in a dispute about something you did before? Which leads to one of the determining factors for any professional who's thinking about what they're doing, and that is, and you tell this to clients too, do you want to fight about the past, or do you want to set the stage for the future? Where do you want to put your money? Do you want to pour it into the past, or do you want to pour it into the future? It's a really good question. And a lot of these things can be much more expensive than they need to be. But if you choose to argue about the past, I just don't know. I won't do it. I just, there's just no point. Okay. So honesty and truthfulness, well, obviously, you as an attorney, you can't commit fraud. You can't be deceitful. You can't misrepresent stuff. Especially if in a transaction they're going to find out anyway. Here, just for this one transaction, for this one client, let me hand you my bar license and a pair of scissors. And you can just cut it up whenever you want. That's what you're saying. You're saying you don't want a career in this field. It's okay to do that you think you could shave a little here and shave a little there and get away with it. That's not a good idea. The best way to do it is just to be as above board as possible. If you don't know, see, here's one of the hardest things for an attorney to learn to say. You ready? I don't know. Here's a better one. I don't have any idea, but I could look into it if you want. Because when it comes right down to it, attorneys are good translators and they're good researchers, but we don't know everything. So let's please not pretend that we do. So you may, as an attorney, serve as a third-party neutral in mediation. But again, you need to focus on who is your client, and you need to be above board with the people you're working with about what position you're operating in. And this is what we mentioned at the beginning, where you may start out as an advisor, then you turn into a mediator, the mediation fails, and suddenly you're an advocate. But now, as an advocate, did you do something in the mediation that would lead the other party to do something, or did lead the other party to do something, so that you can't advocate fairly? And I'll go back to your scenario before. If this client hires me, now they're a former client, or maybe a current client for sure, but the former client, it's a little weaker. So I go to my former client and I say, Parcel B owner wants me to work for him. And Parcel B says, okay, I'll let you work with A, and A says, I'll let you work with B, and that's okay. Now, in some situations where they're directly in conflict, you just can't do that. But if you think you could mediate a role, get into a mediator's role between these two, it does get kind of dicey. You have to get the whole thing in writing. And then furthermore, you have to tell them that if either one of you gets into a conflict over what we're handling right now, I have to withdraw and I can't represent either of you. In other words, I'm going away completely. So you'll need 2 brand new attorneys. Now, once you explain that to someone, then usually the better course is to say, why don't I just handle B, or I'll handle A, and you, B, go get your own legal counsel. Because then I know the protections are in place. The attorney-client privilege, the loyalty, the confidentiality, the attorney, it's all there. Everybody's protected, eyes wide open, they've got their own counsel, and there's no issue. And we can usually work it out if it's work-outable. There's some problems in the world that you need a court to help you with. But there's a large amount of problems that you don't really need to go to court at all. You just need a good opposing counsel who takes the translation function seriously and understands what the positions are, and then you can just hammer something out and make it go. But if the attorney has to withdraw from both, and that's something that you got to tell them up front. By the way, you might lose me, former client. Former client's going to go, well, I'm not so sure I want to sign this. And I say, well, that's your decision. No question. Okay. So the key is, for these transactions, your client wants to have a transaction. They do not want a transaction that ends up into a lawsuit. I never had one client ever walk into my office and say, you know, I'd like to do a real estate deal and then have a gargantuan 5-year lawsuit after it. Can you help me set that up, Art? It doesn't happen. It doesn't happen once. And why would a good attorney do something in a transactional situation, whether it's crafting language, negotiating, or whatever, that would lead their client into a lawsuit? Is that really representing the client? You got to say no. You got to say no. Now, the words fair dealing do not appear in the Washington Rules of Professional Conduct. They're just not there. But there is, in every contract in Washington, an implied duty of good faith and fair dealing in every contract that obligates the parties to cooperate with one another so that each may obtain the full benefit of performance. So if you're familiar with contract law, what you have is usually 2, but sometimes more parties, and one party makes a promise, and the other party says, well, after you do your promise, I'll keep mine. And then this guy goes, and after that, I'll do this, and after this, I'll do this. And then in the end, we'll meet and close the transaction. So there's a performance, a performance, a performance, a performance. Sometimes it's money, sometimes it's a disclosure, sometimes it's an inspection, sometimes it's whatever. But there's a performance, performance, performance by both parties, and then they close. And if this is all done properly according to a calendar, which is the calendar of the performances of the contract, and if it's well worded and it's specific, so you have exactly what they're going to do, when they're going to do it, and then a remedy if they don't do it. And it has to be quick, because the calendar keeps going. I mean, the calendar, tempus fugit, right? Time stops for no man is what they say. And it's true. So we want to work with good faith and fair dealing, and that means that each party is going to get the full benefit of what they entered into the contract for. And if we go to court on a contract, one of the things the court's going to do is, what is the expectation of the parties? There's actually a conclusion, a characterization of certain damages in contract cases called expectation damages. What did you expect to get out of it? So here's the, later on in the materials, the material fact is information that substantially adversely affects the value of the property, or a party's ability to perform its obligations in a transaction, or operates to materially impair or defeat the purpose of the transaction. So let me ask you, what if there's something just spectacularly great about this property? It's not a material defect. It's not something that downgrades the property. What if it upgrades the property? They're about to declare a 500-acre parcel next door as state preserve lands, and there can be no houses built there. Is this a material defect? To most people, it would be a benefit. Wow, no neighbors over the back fence. Whew, that's awesome. And so even if there was an oil tank in the basement and your seller decides not to remediate it, against my best advice, they still have the preserve going in next door. So the buyer's going like this: oil tank, preserve, oil tank, preserve. What am I going to do? And so you can mitigate the material defects, but you cannot say, well, I'm not going to tell you about them. You got to disclose them. But if you're going to disclose something that's bad, why don't you think about something else that's good, that goes with it? You know, there is an oil tank in the basement, and we've got some bids on getting it, remediated. But I notice you have 3 kids. Did you know that this local school system has the best scores in the county for elementary school kids? Here is what I base that representation on. Now, that might actually pull them away from being so concerned about the oil tank in the basement. It still's got to be dealt with. Let's not pretend that you don't deal with it. You do. But you do it in the context of other facts. Okay, practicing in areas of competence or training. We've only got a couple minutes. But let me ask you, I consider myself to be fairly competent in the areas of real estate, easements, boundaries, this type of thing. I've been doing it 12 years in 2 states for sure. But a question arises, how many dates are there on a deed? You've all seen deeds before. How many dates are there? There could be one at the top. There could be one near the signature line. There could be one where the recorder made the stamp at the auditor's office. There could be one where the notary did their thing. So now there's 4 dates. Which date do we use? Now, if you don't do real estate a lot, you might not know how the law treats that. But for some purposes, the law will treat it as it's the one next to the signature lines, as between the parties. But otherwise, it's probably going to be the recording stamp, because that's the date it went into the public record. So some of our border areas we see as real property attorneys, estates, wills and trusts, estates, bankruptcy comes up. But these are just the areas of competence and training. When you get there, you should tell people that you're not competent in that area. It's outside of your scope. Okay, let's talk a little bit about referrals. Lawyers cannot make false or misleading communications about their services, which means that lawyers have to be intimately involved with what people are posting on their websites to go get SEO, to get clients to call the office. You need to read your website and say, is this an advertisement that the Bar Association would approve as an ad? Am I making misrepresentations? We guarantee that we'll resolve your problem. No, you can't do that. Can't make any guarantees. I mean, it's really squishy, but it's all for the better. I mean, all you can do is, say we'll do the best we can. Can you pay people as an attorney to go drum up business for you? You get a survey and it says, well, the Bureau of Land Management doesn't record at the recorder's office, but the local surveyors do. And so out at Twin Lakes in Kootenai County, there's like 500 or 600 parcels they found that nobody ever knew were there, because the guy that came through in 1890 with whiskey and, corn dodgers and a donkey, he determined that the meander line was way up there on the cliff. It's 300 feet up. And the water never got there, ever. So the whole place is off. Same with Spirit Lake. It's dicey. Am I going to go call the neighbors and say, hey, you should have heard about this situation at Twin Lakes? No. It's just crazy. But some people do that. We call them colloquially ambulance chasers. But they're chasing more than ambulances. In fact, I can't even talk to somebody and solicit legal business from them in Washington unless they're an attorney, they're a close family member, or they've signed up with a legal services agreement to have an attorney talk to them. So I can't just, cold call people and say, hey, do you need an attorney? Got a problem with your fence? You just can't do that. And I can't pay the little kid on the tricycle to wander around the neighborhood and go, I know a guy who can help you with Mrs. Jones' fence. The question is, do you take money for making referrals? Well, in my book, you don't, because there's a red line there where it seems like I'm paying this person to generate business for me. Art's a really good attorney. He's been doing this a long time. He's really good. They have no idea that I was just in a car accident and I'm laid up in the hospital and I might not recover. So they're making a representation that is clearly not true. They have no idea what they're doing. And where's it going to fall? On me. So where are we? Let's see. We're almost there. I think I want to go to the scenarios. This one, though, I want to talk about briefly, the representations of your office staff. Anybody not answering the phone in their business? Anybody paying somebody to answer the phone? Yeah, probably about everybody. And what are they saying about what you can do for them? You really got to watch this one like a hawk. We actually have scripts that we tell our people when they call, you say certain things, you don't say other things, and if they put you on the spot, you say, I don't have a clue, but we'd be glad to have you in and talk about it. Because it's just better. Teach them the disclaimers. Okay, so here we have scrupulously avoid payment for food, Reciprocal referrals, give the client choices. I need a wills and trusts attorney, Art. You handle my land stuff. Give them 3. I'm a surveyor. Somebody says, I need somebody to help me with this boundary dispute. Give them 3 attorneys. Okay, it's just good business because let them choose. Give them choices. I never met a client that said, I want you to restrict my choices. That says we're done. So I am going to, here's the 2 ethical dilemmas again. But here we run into the same considerations as we did in the earlier class from a different perspective. Who is the client? Who can you speak to? The answer is everybody unless they're represented. Can you call the neighbors? Can you offer them your services? If they're an attorney or a close family member or they asked for it, maybe, but otherwise, probably not. But the end result is that it is up to the attorney to educate anybody they're talking to about what capacity the attorney is, can, or will operate in. And if you're not doing that, you're probably asking to talk more to the State Bar than you really want to. Thank you for your time.